The Supreme Court is scheduled to hear a case that could have a big impact on your love life. The case involves a police officer who used his department-issued BlackBerry to send racy text messages. So where's the line drawn when it comes to using work-issued technology for personal reasons? Joining us now to talk more about that is John Mahoney. He's a partner in the law firm of Tully Rinckey, and he specializes in federal sector employment and labor law. So first, let's talk about this case. By June, we're expecting a decision from the Supreme Court in the case of Quon v. Arch Wireless. The Ninth Circuit Court of Appeals ruled in favor of the employee of the police sergeant, a SWAT team member for the police department in Ontario, California, went over his allotted monthly text message limit, sent sexual nature text messages, and had also signed a computer policy that the company had issued about usage of email and computers. I don't understand that ruling.
Yeah, well, the issue was that the problem with the phone company giving the records to the City of Ontario, the Ninth Circuit found that it was improper for them to do that without a warrant. Now, the issue that's gone to the Supreme Court is whether the City of Ontario properly disciplined Mr. Quon for using his agency-issued BlackBerry to send sext messages on duty. And the issue there is whether the employee had a reasonable expectation of privacy under the Fourth Amendment of the Constitution that would allow him to believe that he could send such sext messages on the agency-issued BlackBerry without getting in trouble. Now, I think the issue before the court is really going to resolve the matter of whether employees have a reasonable expectation of privacy in a company or an employer-issued technology, and I think the answer is going to be no, that they don't have a reasonable expectation of privacy, and therefore, unfortunately, Sergeant Quon's discipline will probably stand.
So what does that mean for federal workers, whether it's a sex text message or any romantic or personal text message for that matter that I might send to my mother or cousin, or any personal message that I want to use on my BlackBerry issued by work?
The federal government allows federal employees a certain amount of personal use in terms of agency-issued technology. However, if an employee uses that agency-issued technology for sexual purposes or for harassing or discriminatory purposes, certainly the agency can discipline the employee. And I don't think there's any reasonable expectation of privacy for a federal employee to use or misuse a technology for sexual purposes.
If the court does in fact rule in the favor of the employer, the police department in this case, could that mean that employees should be even more concerned and more uptight about how they are using their personal devices? What kind of impact would that law have?
Well, I think the impact is clear. I think employees need to realize, in my opinion, that they don't have a reasonable expectation of privacy in technology, BlackBerries or computers that their employers issue them for official use. They're not supposed to be using official use technology for personal or certainly not for sexually misconduct reasons. And if they do so, they can face termination. And I know the federal government's policy is that they typically remove federal employees for doing such things.
Valentine's Day is right around the corner.
It is.
Interesting. A 2008 survey from Vault.com found 46% of professionals have been involved in an office relationship or romance. But when the love fades, that's where you get into some really complicated issues, some legal issues even. Is it worth the risk of even getting involved?
It's not worth the risk, but as the survey says, 46% of the 1,000 or so professionals surveyed did admit to having some type of office romance. The danger is that if that office romance, which may have been consensual at the beginning, fades and becomes non-consensual, the employee can face discipline for sexual harassment or for discrimination if the person favors their paramour in the workplace over other employees, especially if the person is a supervisor. So it's a big danger, and I'm here to tell employees, especially federal employees, that it's not a good idea to get involved with relationships in the workplace.
Watch what you send and watch what you say at work.
Exactly.
John Mahoney from Tully Rinckey, thank you for joining us tonight.
Thanks, Mike.